We have some breaking developments in the ongoing legal battle against the ATF's pistol brace rule. This fight has been closely watched because it impacts millions of gun owners across the country who legally purchased brace-equipped pistols, only to have them suddenly reclassified as short-barreled rifles under federal law. Recently, something very significant happened. The Department of Justice under the Trump administration has decided to take a new approach. In the Fifth Circuit Court of Appeals, the DOJ has formally agreed to withdraw its appeal in the Mock v. Garland case, one of the most important lawsuits challenging the ATF's brace regulation. This move effectively means they are no longer contesting the lower court's ruling in favor of the plaintiffs. To understand why this matters, let's go back briefly. The Biden administration had previously appealed Judge Reed O'Connor's decision in the Northern District of Texas. Judge O'Connor issued a nationwide vacatur of the pistol brace rule, blocking its enforcement across the entire country. The Biden DOJ didn't want that ruling to stand, so they immediately took it to the Fifth Circuit in hopes of reversing it. But now, with the change in administrations, the Trump DOJ has shifted gears. Instead of continuing the appeal, they have agreed with the plaintiffs to dissolve it altogether. This is a major step, because it signals that the current DOJ is not interested in defending the ATF's rule at the appellate level. Even more importantly, the Trump DOJ is not limiting this to just one case. They have also acknowledged in related lawsuits that they intend to resolve those disputes in the same way. In other words, they are stepping back and allowing Judge O'Connor's ruling to stand as the controlling precedent. That ruling, which vacates the pistol brace rule nationwide, is now officially recognized as the law of the land by the Trump DOJ. This acknowledgement is a huge development. For the first time, we are seeing the federal government itself, under this administration, formally accept that the nationwide vacatur issued by Judge O'Connor is binding and in effect. This completely changes the landscape of the ongoing fight over pistol braces. That ruling was monumental because it wasn't just a procedural decision, it was a final judgment striking down the ATF's pistol brace rule in its entirety. After Judge O'Connor's decision, the Biden administration, through the ATF, immediately tried to fight back. They filed an appeal to the Fifth Circuit Court of Appeals, hoping to overturn Judge O'Connor's ruling and reinstate their regulation. For a while, the case sat in a sort of limbo. This was partly because the Justice Department shifted hands during the transition from the Biden administration to the Trump administration. Under Trump, the DOJ took control of the appeal. A deadline was also set in the process, but that deadline eventually came and went without significant movement. Oral arguments were scheduled to take place in the Fifth Circuit on the pistol brace issue, but then something significant happened. News broke that the Trump DOJ had decided to withdraw its appeal altogether. In other words, the Trump Department of Justice effectively conceded the case. They filed a notice with the court in the mock lawsuit stating that, under the Federal Rules of Appellate Procedure Rule 42(b)(1), both sides agreed to dismiss the appeal, with each party bearing its own costs. What that means in plain terms is this. The ATF acknowledged Judge O'Connor's earlier ruling, which had vacated the pistol brace rule nationwide, and they agreed to step back, allowing that ruling to take effect. Now, this decision in the mock case is important, but it's not the only lawsuit that has been challenging the pistol brace rule. When the ATF first announced its stabilizing brace regulation, multiple gun rights organizations and groups quickly filed lawsuits across different courts. For example, we saw challenges from Gun Owners of America, GOA, the National Association for Gun Rights, NAGR, the Brito case, the NRA's lawsuit, and many others. Most of those cases were filed in the Northern District of Texas, and later made their way to the Fifth Circuit. On top of that, there's also the FRAC lawsuit involving SB Tactical in 25 states, which was filed in the Eighth Circuit. Now here's where it gets interesting. Following the Trump DOJ's dismissal of the mock appeal, the ATF and the plaintiffs in the FRAC lawsuit notified the court that they, too, were working toward resolving their case. Essentially, they recognized that the mock decision had changed the landscape, and there wasn't much point in dragging the fight further. And now we've received notice in yet another case, the NRA's lawsuit in the Northern District of Texas. In that case, the parties also informed the court that they are working on a resolution in light of what just happened in the mock case. What makes this notice stand out is that the Trump DOJ, in its filing, openly acknowledged that the pistol brace rule is vacated because of Mock v. Garland. To be specific, the filing stated that pursuant to the court's April 18, 2024 order, the parties provided an update. On July 25, 2025, the Fifth Circuit granted the stipulation to dismiss the appeal in Mock v. Bondi. Because of that, the final rule at issue, the factoring criteria for firearms with stabilizing braces, commonly referred to as the pistol brace rule, was officially vacated by Mock v. Garland. The notice went on to say that the parties are currently in active discussions to resolve the lawsuit without the need for further litigation, and requested that the court extend its stay for another 14 days while those discussions take place. The key difference here compared to other notices we've seen in related lawsuits is the clarity of the Trump DOJ's statement. They didn't try to sugarcoat it or avoid specifics. They plainly said the pistol brace rule is vacated because of Judge O'Connor's nationwide ruling in Mock. That is an unmistakable acknowledgement that the Trump administration accepts the nationwide vacatur as binding and is not going to pursue enforcement of the rule any further. This is significant news for gun owners because, for months, there's been uncertainty about how the new administration would approach the pistol brace issue. Many were waiting to see whether the Trump DOJ would defend the ATF's rule or step away from it. With this notice, the answer is clear. They are conceding, and they are moving to dismiss and settle the remaining cases rather than continuing a costly legal battle. In short, the Trump administration is signaling that the fight over pistol braces is coming to an end. Judge O'Connor's nationwide ruling now stands as the law of the land, and the DOJ is treating it as final. That's a huge victory for gun rights advocates and for the Second Amendment. Now, one important thing I want to point out about all of this is the long-term impact of these decisions, the settlement agreements, and the choices being made to drop certain appeals and lawsuits. On the surface, agreeing with the Trump DOJ to end these cases gives an immediate victory. It essentially shuts down the pistol brace rule right now because it allows the nationwide vacatur to stand. That means the rule is blocked, and gun owners and manufacturers are free from the restrictions it carried. At least for now. But here's the trade-off. By taking this route, you give up the chance of securing a stronger, more permanent win on the merits at the Court of Appeals level. That type of ruling would have set binding precedent for the future. Instead, what we're left with is a much narrower type of win, one that deals with this particular rule at this particular time but doesn't necessarily protect against future administrations trying the same thing again. To explain why, let's look at the Mock case. Judge O'Connor's decision there was a huge deal, but we have to be clear. It came from a district court judge. District court rulings don't carry binding authority across the country the way appellate or Supreme Court rulings do. That's where the risk comes in. If, for example, a future anti-gun administration wanted to bring back a brace rule, they could very well try again. Why? Because Judge O'Connor's ruling didn't strike down the brace rule based on the Second Amendment. Instead, it was based on a technical issue under the Administrative Procedure Act, or APA. Judge O'Connor found that the rule failed what's called the logical outgrowth test. Here's what that means. When the ATF originally proposed the brace rule, it included Worksheet 4999, which had a detailed point system. Owners would have to score their firearm based on characteristics like weight, length, design, and attachments to determine if it was considered an SBR under the NFA. But when the final rule was published, that worksheet and scoring system were completely removed. In Judge O'Connor's eyes, that was a big problem, because the final rule looked very different from what was originally proposed, and that violated the APA's procedural requirements. So what does that mean for the future? Well, another administration could easily go back and reintroduce a very similar brace rule. The difference is, if they make sure the proposed version matches the final version, they wouldn't run into the same APA problem that got the last rule struck down. In other words, the door is still cracked open for anti-gun policymakers to try again. That's why I've been calling this an immediate victory, but not necessarily a permanent one. It protects gun owners right now, but it leaves room for future challenges. Still, this is the route that the Trump DOJ, along with the plaintiffs, organizations, and parties involved, have decided to take. They're choosing to resolve these cases by leaning on the nationwide vacatur from Mock instead of fighting it all the way to a final appellate decision. It's also important to note that many of these other cases, the FRAC challenge, the NRA's challenge, and others, were already tied up and essentially waiting on what would happen in Mock. Now that Mock has been resolved in this way, It looks very likely that those other cases will also end the same way, with dismissals and settlements that rely on the current outcome. So, as it stands, the brace rule has been effectively dismantled. That's the immediate reality. But looking ahead, it's still possible for future administrations to circle back with another version of the rule that passes APA requirements. We'll just have to wait and see if that happens. For now, though, this is where things stand in the ongoing brace challenges. These cases have been in the works for a long time, and this resolution, while not the perfect endgame many people hoped for, still delivers meaningful relief today. As always, I'll keep you updated as more details unfold and as these cases continue to wrap up. If you found this breakdown helpful and you want to support the channel, the best way to do that is to like, comment, and subscribe. Your support means a lot, and I truly appreciate every one of you who follows along with these updates.